Good afternoon, everyone. My name is Mixie, and today I'll be speaking about the ruling of a Supreme Court case that occurred in May of 2023, National Pork Producer Council versus Karen Ross. Now, while the animal welfare laws are the subject of the court case, we're going to quickly learn that it's not actually about the animals. In addition to talking about constitutional law, we're also going to be seeing elements of the checks and balances that exist between the branches of government, states' rights, commerce laws, precedent, and preemption. Before we begin, let's quickly address the agenda. I'll start with the facts of the case and how we got to the courtroom, the legal issue brought forward by the plaintiffs, theirs and the defendants' arguments, the court decision and their opinions, followed by the impact that it has on the businesses and the nation as a whole, as well as a moment to critically evaluate the implications of this case. Now, the first image you saw was of a mother pig, known as a sow, pinned on its side while its young nursed. This is called a gestation crate. When not actively in use, the sow is contained within the pen and doesn't even have enough room to turn around. Recognizing the negative impact it was having on the welfare of the animal and the need for change, California, in 2018, passed a law known as Proposition 12 with 63% support. From then on, pork sold within its borders needed to come from animals living in better conditions. Kendra Ross served as the Secretary of the California Department of Food and Agriculture. Interestingly, California itself produces very little pork. Less than 1% of the pork consumed is domestic. The rest is brought in across state lines from the largest pork producers in the nation: Iowa, Minnesota, and North Carolina, to name a few. 13% of all pork consumption in the U.S. comes from California. The National Pork Producers Council, NPPC, cried foul and sued, representing over 60,000 pork producers across the country. They argued that commerce laws had been broken and that extraterritoriality had occurred. In essence, California had enacted policies that reached well beyond its borders. They would end up losing in both district court and the Ninth Circuit before bringing its case before the Supreme Court. Oral arguments were heard by the court on October of 2022, and a decision was rendered on May 11, 2023. The Commerce Clause gives Congress the power to enact legislation as it relates to trade, be it international, interstate, or with tribal nations. However, Congress doesn't have a law for every specific trade agreement. When there isn't legislation, the dormant Commerce Clause takes effect. This is a sort of inverse to the rule that if a rule doesn't already exist, this one now serves as a preemptive measure to essentially guard against protectionism and extraterritoriality. Some states may try to pass a law that favors them greatly and hurts, discriminates, and inhibits another state in the process. This brings us to the legal question: was the dormant Commerce Clause violated? The NPPC argued that the new law, Proposition 12, was discriminatory towards the other states because it was forcing them to change their practices, policies, and way of conducting business, all to satisfy California's moral interest. They referred to 3 previous court cases hoping the court would grant precedence: Healy v. Beer Institute, Brown-Forman Distillers Corp. v. New York State Liquor Authority, and Baldwin v. GAF-CLIC. Now, Healy was related to the sale of beer, Brown to liquor sales, and Baldwin to milk. Each of these cases had something in common. New York was preventing out-of-state sellers from selling products below the minimum that New York had set. So, if a bottle of milk, liquor, or beer cost $5 in New York, sellers from Rhode Island couldn't come in and sell at $4. Those laws were seen as violations of the dormant Commerce Clause because they were essentially protectionist towards New York's interest. They also referred to a case known as Pike v. Bruce Church, which essentially, and I quote, assesses the burden imposed on interstate commerce by a state law and prevent its enforcement if the law's burdens are clearly excessive in relation to the putative local benefits. This has now come to be known as the Pike's Test. California is creating legislation that is morally beneficial to its citizens while causing an economic burden for out-of-state producers of pork. The cost to upgrade facilities to meet the requirements of Proposition 12, according to the NPPC, would cost hundreds of millions of dollars. While the price would increase for producer and consumer alike, the producer would be forced to share the brunt of the burden in the short run. If California can pass a law, what is to stop other states from following suit and creating a patchwork of pork laws? This could jeopardize smaller-scale businesses, which could threaten the food system and national security. California's defense is a little bit more straightforward. They claim that Proposition 12 is applicable only to the pork that is sold within their borders, and that they have a right to regulate any product for the health, safety, and moral values of its citizens. They also said that the Dormant Commerce Clause is not applicable because this measure affects all pork, including California's. No favoritism or discrimination is occurring. Finally, they're not telling businesses in other states how to conduct their operations. If the producer does not wish to comply with Proposition 12, they are free to sell their pork anywhere else they please. And the court agreed with Ross. In a 5-4 affirmation, they upheld the Ninth Circuit Court's decision. Proposition 12 remains in effect as constitutional. Ross wins, NPPC loses. They argued that the Dormant Clause was not applicable as it was to the cases that the plaintiffs brought forward, Healy, Brown, and Baldwin. The plaintiffs read too much into too little. The opinion of the court, I quote, is, "The language of an opinion is not always to be parsed as though we were dealing with the language of a statute." It was the justice's opinion that the cases were specific to their time and place. There really wasn't much to draw from. Proposition 12 does not force states into compliance with California and is not an issue of extraterritoriality. Many state laws create ripple effects across the nation. To go after them all would be a massive swing of judicial might that the court does not want to attempt to exercise. There was disagreement about Pike's test. 2 other justices sided with Justice Gorsuch that it's difficult to weigh a moral issue against an economic issue. I quote, "It's trying to verify if a line is as long as a rock is heavy." The other 6 justices did not agree with this opinion and suggested that, yes, a moral benefit can be measured against an economic burden. However, the plaintiffs were suggesting that the court be the one to determine that value and make that assessment. No court is equipped for that. Justice Gorsuch went on to suggest that since this is a matter of Commerce Clause, NPPC should lobby and get Congress to pass legislation if they feel so strongly about the matter. The California effect is real. They've passed legislation with emission standards on vehicles before, for example. It is not economically viable for manufacturers to produce a vehicle that meets California specifications and then produce a different version of the same vehicle for the rest of the country. It's just better to make the Cali spec and sell it to the rest of the nation. Similarly, Washington has wanted to do away with daylight savings time, but isn't willing to do it unless Oregon does, and Oregon isn't willing to do it until California does. A lot of states look to California to see what policy will come out of it. California has the largest GDP and population in the nation. Blue states tend to favor government regulation. When California acts, it sends ripple effects across the other states, including the red ones that favor deregulation. The pork producers will comply with Proposition 12. It would be poor business practice to stop selling to California when it makes up 13% of pork sales. It's also not economically viable to produce pork in 2 separate ways, one for the nation and one for California. At any point, Congress can come in and pass legislation to override Proposition 12. States' rights are in effect until they do. Remember, federal law preempts state law in every instance, and there have been instances where they've tried to preempt California's Proposition 12. Most recently, they tried to add the Save Our Bacon Act, H.R. 4673, to the most recent Farm Bill, which would have shut down Proposition 12. That is unlikely to pass, and it would be unwise to do so at this point. Many of the pork producers have already upgraded their facilities to meet California standards. It would be a blunder to reverse course and go back to the previous model. Retracting that now would be a wasted investment. In a separate opinion, Justice Kavanaugh did pen an argument that Proposition 12 is an overreach by California, and that if this law is allowed to stand, then it does open for the patchwork of laws by other states. And that this goes beyond pork. He wonders if this push if this pushes states to pass laws as they relate to immigration or abortion. I think the most important thing that I learned about this case is that it had nothing to do with animal welfare. Yes, the pigs did get their day in court and came out of it with a better standard of living and care, but it had nothing to do with them. The case had everything to do with the Dormant Commerce Clause, extraterritoriality, states' rights, and the fact that California can swing a pretty big stick. At over 99% imported, it's safe to say that California doesn't produce pork, yet created a law knowing that it would affect practices in other states. No business needed to sell to California, but California has 40 million citizens behind it, and you can't just walk away from that. California does carry a lot of political weight on the national level, and that's a truth that many will have to sit with in the common election cycles. With Proposition 12 deemed constitutional, what precedent is set and what is the future by other laws that California or other blue states may pass? How will these laws affect the rest of the nation? And as we chart forward, the branches will need to continue to exercise the separation of powers. I believe the justices did the right thing by ruling Proposition 12 a constitutional law. It would have been a massive overreach for them to utilize the Dormant Clause in this way. Now that both Pike's Test and the Dormant Clause have been reviewed in this new light, it's likely to be used again in future upcoming cases. This solidifies the idea that it's never about the case, it's about the precedent it sets. NPPC will need to complain to the legislative branch to see their pigs back in cages. This is further proof that having a system of checks and balances is crucial for the health of the nation. And so, like I said, today the pigs had their day in court. Tomorrow was veiled in uncertainty. This has been the National Pork Producer Council versus Karen Ross by me, Mitzi. I would really love to know your feedback, your thoughts, opinions, and how I can do better. Thank you so much for listening to my presentation, and I wish you all well. Take care.